to Hammond Pole's Family Law Update. My name is Tania Abbotts and I'm the General Litigation Attorney at the firm. I'd like to share with you a recent judgment that has forever altered the way that a divorce will be attended to in South Africa. In order to do so, I need to give you a crash course in matrimonial law. In South Africa, you can be married in community of property, which means you and your spouse will share one joint estate. Alternatively, you can be married out of community of property, which means you and your spouse will have your own independent estates. If you're married out of community of property, you can further decide to get married without accrual, which means your estate remains your estate. What's mine is mine, what's yours remains yours. Alternatively, you can be married with accrual. With accrual simply means that your attorney will need to assess the value that your estate has increased from when you got married in terms of your ANC to the date of your divorce. That increase will then be compared to your spouse's increase, and if there is a difference between the two, then the difference will be shared. How would one evaluate the net value of their estate at the time of divorce? Well, simply put, we would look at your total assets and deduct your liabilities. Your assets would include a house, savings, your car. The Divorce Act 70 of 1979 further stipulated that a pensionable interest could be seen as an asset. A pensionable interest includes a retirement annuity, a pension fund, or a provident fund. The problem, however, was that a living annuity was not seen as part of a pensionable interest. A living annuity is a financial product which transforms the initial capital investment, being your retirement annuity, into a guaranteed income until the day you die. What does this mean? If I am married and my spouse has not increased his estate from the date that we were married, then my spouse has a 50% claim to any increase in my estate. If in 2020 my retirement annuity is the sum of the increase of my estate, and my retirement annuity is worth 100 million rand, then my spouse in the year 2020 would be entitled to 50 million rand. If, however, in the year 2021, I invest my retirement annuity into a living annuity, well, then my spouse's claim would be zero. I'm sure you'll agree that this would be a devastating outcome to my spouse. And this is what was challenged at the Joburg High Court in 2016 in the case of Montanari versus Montanari. Unfortunately, the judge ruled that a living annuity has no value for the purposes of calculating the accrual, and it only has a value for calculating a spousal's maintenance claim. This was appealed. And I'm proud to say in May 2020, the matrimonial law in South Africa has forever changed. They agreed that you cannot take the value of the retirement annuity before it becomes a living annuity for purposes of your accrual calculation. But the income that a person gets from their living annuity has a value. And once an actuary is able to determine that value would form part of your accrual calculations. In conclusion, the loophole once used to diminish a party's estate for purposes of an accrual calculation has forever been closed, and a living annuity can no longer be used to take advantage of the other party for purposes of calculating the accrual. Thank you.